I'm Professor Diane Klein, and this is Federal Civil Procedure. For all of you who are taking the bar exam after February of 2015, you are experiencing the most significant change to the multi-state bar exam in about 35 years, and that is the addition of a new subject to the multi-state. Federal Civil Procedure has long been one of the bar exam subjects on the essay side, and also on performance tests, but not on the multi-state. So the past few administrations of the multi-state bar exam have included the development of many new questions in the Federal Civil Procedure area, some of which were tested in an experimental way in the years preceding and have now been validated and finalized for use on the bar exam. Because Federal Civil Procedure is a large and in some ways complicated subject, there are only certain subparts of it that tend to be susceptible or suitable for multiple choice examination. And those are the areas that we will be focusing on in working through some sample questions and focusing on those areas of Federal Civil Procedure. So what I'll be talking about is certainly not the entirety of the subject, and not even necessarily the entirety of the subject as it may be bar examined, but rather that part of the subject that has historically, although we only have a few administrations worth of history, been most heavily tested in the multiple choice format. So the first of these subjects is, appropriately, subject matter jurisdiction. When I taught Federal Civil Procedure, which I did for many years at the beginning of my career, I reiterated to students that any essay question that involves subject matter jurisdiction should begin more or less verbatim with the sentence, federal courts are courts of limited subject matter jurisdiction. Unlike state courts, which can hear cases of virtually any kind, although there are sometimes specialty courts, traffic court, family court, and so on, pretty much any dispute that can be litigated in an appropriate arm of the relevant jurisdiction state courts. Not so the federal courts. Because federal courts are courts of limited subject matter jurisdiction, the appropriateness and satisfaction of the requirements of federal subject matter jurisdiction must be met with respect to every case, and more specifically, every claim in the federal case. In order to be heard by a federal district court, the case must qualify under one of the two bases for federal subject matter jurisdiction, either diversity of citizenship or federal question jurisdiction. If neither of these exists, then the case is susceptible to dismissal under Rule 12b-1 for lack of federal subject matter jurisdiction, and the defendant will prevail in such a motion, which is one of the ways that such questions might be asked. There must be an appropriate basis of jurisdiction for every claim in the case, and we'll see what that means when we talk about multi-claim cases or cases that include cross-claims, counterclaims, supplemental jurisdiction, ancillary jurisdiction, and so on. But we'll begin with diversity cases. The requirements of diversity jurisdiction have two topic areas. The first is the citizenship of the parties, and the second is the amount in controversy. We'll begin with the citizenship of the parties. In order to determine whether there is diversity of citizenship between the parties in the lawsuit, you obviously have to determine the citizenship of each party. For natural persons, what we're looking for is domicile, and domicile has two components, an objective and a subjective component. The objective component of an individual's domicile is the state that they are in. The subjective component is their intent to remain there and make it their home. So, obviously, people travel from state to state. Merely being in a state does not render that state your domicile, unless that person has an intent to remain there, which is to say, to make that state their domicile. If someone has residences in more than one state, it is still the case that for a natural person, they have at most one U.S. state of domicile. A corporation, that is a non-natural person, a corporation is a legal person, but not a natural person, a corporation may have as many as two states of domicile. The first is the corporation's state of incorporation, And the second, which may be different or may be the same, is that corporation's principal place of business. Partnerships and unincorporated associations are not persons in this sense. They have no domicile of their own, and instead they are citizens, domiciliaries, of any and all states where the partners, or as the case may be, the members reside. If you reflect on that for a moment, you realize that with a large partnership or very large unincorporated association, it is possible that it will have members, partners, who are domiciled in every state, and as a result, that partnership or unincorporated association may not be of diverse citizenship with respect to anyone who they might be suing or be sued by, and diversity jurisdiction would therefore be unavailable to them. But as to natural persons or non-natural persons, corporations, it is at least possible that they can be of diverse citizenship from the parties on the other side of the lawsuit. The next page of our materials includes a fill-in chart that is just a quick recap of the rules for citizenship, domiciliary status, in a few different situations. So, of which state is each of these persons a citizen? So, a person resides in state A, but is planning to move to state B in 3 months. That person is still domiciled in state A. That is, the intent to make state B their home is not enough to make it their domicile until physical presence and intent to remain co-occur. A person has moved to state B permanently and is renting an apartment there, but still owns a home in state A. This person is domiciled in state B. They are present in state B with an intent to make it their home, that they continue to own a residence in state A, their former state of domicile, does not prevent state B from being their current state of domicile for diversity purposes. Suppose a person owns homes in states A, B, and C and spends approximately equal time in each. Her birthplace is state A, where she also has her driver's license and is registered to vote. In this relatively easy case, the person is still domiciled in state A. We don't approach a problem like this neutral as between all of the possible states. With these facts, you're told this person was born in state A, has their driver's license there, and is registered to vote there. The question, therefore, would be whether the acquisition of additional residences in states B and C, where the person spends approximately 4 months a year in each, that is, in state A for only about 4 months a year, is sufficient to change that person's domicile from state A to either state B or C, and it is not. Next, we'll consider a corporation. A corporation is incorporated in state A and has its primary place of business in state B. A corporation, a non-natural person, can be domiciled in both of those states, state A and state B. A corporation is incorporated in state A and does business in all 50 states. That corporation is a domiciliary, a citizen of state A. On these facts, it has no principal place of business other than in state A, and hence is only a citizen, for diversity purposes, of state A. A different corporation, let's suppose, is incorporated in state A, but does no business there. All of its business operations are in state B. In that case, it is a citizen of state A based on its incorporation there, and of state B based on doing business there. Again, relatively straightforward. A corporation is incorporated in state A, has its corporate offices in state B, and has a manufacturing facility in state C. At an earlier time, there was some litigation and the development of tests about principal place of business, with the so-called nerve center versus muscle center tests being somewhat in play. Now the predominant approach is where corporate decision-making is made. The so-called nerve center approach tells us what the principal place of business is versus other business activities. And so this corporation is a citizen of state A based on being incorporated there, and of State B based on having the corporate offices there, the nerve center test, and the manufacturing facilities are not relevant for these purposes. Now consider a partnership whose office is located in State A and has 8 partners domiciled in State B and 2 domiciled in State C. Here we're not using a principal place of business approach. Remember that a partnership does not have a separate legal personhood for diversity of citizenship purposes from the constituent partners. Instead, we attribute to the partnership the legal states of citizenship or domicile of each of the partners. Again, not looking at which one is predominant, and so this partnership is in State B and State C, not State A, where the partnership office is located, because no partner is domiciled there. And finally, an unincorporated association has its national headquarters in State A with members in all 50 states. This unincorporated association is a citizen of all 50 states, and as a result is not of diverse citizenship from any U.S. citizen domiciled in any of the 50 states. The second component for satisfying diversity jurisdiction is the amount in controversy. The amount in controversy in a diversity case, intended to make sure that cases brought in federal court are reasonably substantial, is in excess of $75,000, exclusive of interest and costs. This is the amount the plaintiff, in good faith, could reasonably recover if he or she prevails. A plaintiff may aggregate his or her claims against a particular defendant, that is, all of the claims against a single defendant may be aggregated to meet the amount in controversy, but may not combine claims against separate defendants to meet the amount, nor may multiple plaintiffs aggregate their claims to meet this amount. Note, however, that multiple plaintiffs may aggregate their undivided interests as against a particular defendant. So if multiple plaintiffs have an undivided interest that taken together exceeds $75,000, it can be asserted against a single defendant, assuming diversity of citizenship is met. We have a question, our first question in our materials, that requires you to apply these rules. Question 1. 2 individuals sue a corporation incorporated in California and having its principal place of business in Nevada in federal court on multiple claims of fraud. One of the individuals is domiciled in Colorado and the other is domiciled in Nevada. The individuals seek $100,000, $50,000 in compensatory damages and $50,000 in punitive damages, which applicable law allows on fraud claims of this type. The corporation files a motion to dismiss for lack of subject matter jurisdiction. Should the motion be granted? Before we consider the answers, and I indicate to you which of them is correct, let me make a few remarks about the structure of this question, which is typical of MBE questions. So this may have been covered by another instructor. What I'm going to say is of general application to MBE questions of all kinds. And that is, it is a very typical question structure in terms of the logic of the question. This yes because, no because type of structure. So what this requires you to do, first, although these things can be done in either order, the first of the things you need to do is figure out the yes-no side. And then the other is to select, once you're on the yes-no side, the correct issue. Part of preparing effectively to answer MBE questions quickly and correctly involves not just learning lots and lots of rules in civil procedure and other subjects, but also developing good, reliable intuitions on the yes-no question. Once you have such reliable intuitions, it's often very easy to figure out which of the 2 answers on the yes or no side of the question is the right one, because one will connect quite obviously to the issue and the other much less obviously. Now, sometimes, of course, you will encounter questions where you don't have a very good intuition on the yes-no issue. That is the fundamental issue of the question. And instead, you will see the issue correctly, and be kind of stuck between the yes answer and the no answer, both of which relate to the relevant issue. And in that case, there's nothing for it but to read very carefully to see if one of those choices, for example, either misrepresents the facts of the question or contains a misstatement of the law or the applicable rule in the situation. So here, the corporation has filed a motion to dismiss, and in determining, notice that the question says the corporation files a motion to dismiss for lack of subject matter jurisdiction without you having been told already that this is a diversity case necessarily, right? You haven't been told that it isn't one or that it is one. And one of the things that, of course, makes the actual MBE challenging is that as you encounter questions, you don't even know which subject matter they are in, much less which subpart of the area. So in looking at a question like this, you would look at the call of the question first. It might just be, should the motion be granted, which isn't going to even tell you that this is a civil procedure question, much less that it's a subject matter jurisdiction question. But if you go back a sentence, you see the corporation files a motion to dismiss for lack of subject matter jurisdiction. Another way that a question like this might be framed on the current version of the MBE is, should the corporation's motion to dismiss for lack of subject matter jurisdiction be granted? And if that were the case, you would be able to see at a glance that this is a subject matter jurisdiction question. It's a 12b1 question. Then, when you read through the facts, you would be looking for the facts that establish diversity jurisdiction, or, as we'll see when we come to the end of this unit, federal question jurisdiction, to see if they are there. This question has given you absolutely nothing to suggest the presence of a federal question. It's therefore necessarily a diversity question. And one of the easiest ways to deal with diversity subject matter questions is to make yourself a simple chart as you're going along that has, a simple chart that is plaintiff states and defendant states, whether you have one party or multiple parties. So here, our plaintiffs, we have two individuals. The plaintiffs are domiciled in Colorado and Nevada. And our defendant is a corporation incorporated in California and having its principal place of business in Nevada. So of what states is this corporation a citizen? California, based on incorporation, and Nevada, based on its principal place of business. So you have to know the principal place of business test. Once you know that a corporation can also be a citizen of a state in which it has its principal place of business, you see that we have a Nevada citizen on both sides of the chart, and as a result, there's no diversity of citizenship here. And so, should the corporation's motion to dismiss for lack of subject matter jurisdiction be granted? Yes. The yes-no question is easy because, as the chart shows us, we have Nevada citizens on both sides of the line. Then we look at our yes answers to choose between them. Yes, because the parties are not diverse. Yes, because the parties are not diverse and the amount in controversy requirement is not met. So, an easier version of this question would say A, yes, because the parties are not diverse, and B, yes, because the amount in controversy is not met. In that case, the only analysis would be of the citizenship, and you would know A was right. But as we see here, both of the yes answers indicate that the parties are not of diverse citizenship. So that's not going to help us choose between them. We actually have to do the second part of a diversity jurisdiction analysis, which is about the amount in controversy. So then we look back up here and see the individuals seek $100,000. $100,000 exceeds the $75,000 plus jurisdictional minimum. And then there's a little sub-rule in here. We have two plaintiffs, but it's a single claim against a single defendant, so there's no problem. And there is no rule that would prevent either the compensatory or the punitive damages from counting. The question is made even easier because you're told that applicable law allows these amounts and types of claims, And so the amount in controversy is not a problem. As a result, A is the correct answer. Moving on, as the headline in the next part of our material suggests, complete diversity is required unless it isn't. So as I have been emphasizing, the diversity statute requires complete diversity of citizenship, meaning, as we saw in the last question, that if even one plaintiff and one defendant have the same domicile, even if it is the second domicile of the defendant, diversity is destroyed, and if there's no federal question, there's no federal jurisdiction. However, parties who are impleaded, substituted, or intervening by right need not be diverse, nor must the amount in controversy be independently met as to the claims relating to them. Supplemental claims arising from the same case or controversy, and we'll talk a little more about that, and have a common nucleus of operative fact, may be heard as part of a properly pleaded diversity case. That is, diverse plaintiffs and defendants with the amount in controversy in the main claim exceeding the minimum, without meeting the diversity requirements on their own. So these are a variety of situations in which a case that is a proper diversity case can include some other claims and parties that do not independently satisfy the requirements of diversity jurisdiction. We have another couple of questions in this area. So, question number 2. A domiciliary of New York was bicycling through Vermont on a fall foliage tour when she was struck by an automobile driven by a New Hampshire domiciliary and thrown from her bike. The driver then rammed into a wall. The New Yorker sued the New Hampshire driver in federal district court for her injuries, seeking $65,000. And that, of course, should be setting off alarm bells, because recall the jurisdictional minimum exceeds $75,000. The New Hampshire driver properly impleaded a Vermont driver, alleging that the Vermont driver stopped short, forcing the New Hampshire driver off to the side of the road, where he struck the New Yorker. The New Hampshire driver sought contribution for the New Yorker's damages, as well as $15,000 in damages to the New Hampshire driver's car. If this case is dismissed, what is the most likely basis for the dismissal? So this is a broader question. Because we've read through it, we see that it's a federal diversity case, if it's any federal case at all. And again, we want to do the same little chart. And we'll probably want a little chart of the lawsuit too, because once you've got a few different states involved, things start to get a little bit more complicated. So, as we see in the middle of the question, the New Yorker sues the New Hampshire driver. So the New Yorker is our plaintiff. The New Hampshire driver is our defendant. And if we just want a chart of the action, it's New Yorker suing New Hampshire driver, who then impleads the Vermonter, alleging that the Vermont driver stopped short, etc., and seeking contribution as well as $15,000. So there's 65 sought here and 15 sought here. So we see diversity of citizenship. That's not a problem, even if we count the impleaded party, which we don't have to do for these purposes, but we still have diversity of citizenship. The question, however, is if you have remembered, which is kind of the easy part of the question, that the amount in controversy must exceed $75,000. It'll be clear that this is insufficient. The question is whether this can be added to it. That's the basic yes or no question. Can damages sought by an impleaded, in an impleader action, right, by the defendant against an impleaded other defendant, be added to meet the amount in controversy? Recall again from our prior page the statement about how the amount in controversy is to be calculated for meeting this requirement. Okay? And that is, back a couple of pages, the amount the plaintiff in good faith could reasonably recover if he or she prevails. The plaintiff is not going to get more than that amount. And so The amount in controversy is not met. On the yes-no question, then, what we're looking for is that the amount in controversy is not met. That's the defect, not the citizenship defect. Notice that this question is not phrased in this yes because, no because format. It doesn't have that logical structure. It's instead asking for the likeliest basis for the dismissal. Right? Now we have to read through them, right? Although we're looking for amount in controversy. A, the requirements of diversity of citizenship are not satisfied. That's just false. The amount in controversy requirement is not satisfied. That's correct, so we have to see if there's a still better answer. The requirements of diversity of citizenship and of amount in controversy are not satisfied. False. There is no federal question presented, not even relevant, right? It is true that if a federal question were presented, it would be, the motion to dismiss would not be granted, but there's nothing in our question to suggest that that's what the question is about. So if it is dismissed, it is true. Impliedly, there is also no federal question presented, but the superior answer that connects more directly to the facts is that the amount in controversy requirement is not satisfied. The next of our questions is question 3. A domiciliary of Kentucky is suing a domiciliary of Ohio. So now we've got this chart in hand. Doesn't look like a problem so far. Over a disputed claim to a parcel of property located in Kentucky. The parcel is worth $100,000. Another Ohio domiciliary claims an interest in the property and seeks to intervene. If the would-be intervener's motion is granted, may the case be heard in federal court? That's our question. So we have someone, here's our action. Right, the parcel is in Kentucky, and there is a second Ohioan who is seeking to intervene. May the case be heard in federal court if the intervention happens? Well, we can see from our chart, if this person intervenes on this side, diversity of citizenship will be destroyed. This person. But if they intervene on this side, it won't be. And that we want to go looking for that answer. This is again, yes because, no because, no because. So exactly how the answer will be phrased, not necessarily obvious in advance, but what we can see is we want them on this side of the case to preserve complete diversity and allow the case to proceed. Answer A, yes, so long as the second Ohio domiciliary seeks to intervene as a plaintiff. Well, that has it backwards. If they seek to intervene as a plaintiff and the motion is granted, diversity is destroyed. B, yes, so long as the second Ohio domiciliary seeks to intervene as a defendant. Well, that works, so that's at least a possible answer. If they seek to intervene as a defendant, diversity is not destroyed. C, no, because complete diversity will be destroyed. Well, now, as we see, having read through answers A and B, it depends on which side they intervene. And D, no, because supplemental jurisdiction is not available when jurisdiction is based on diversity. That is simply a false statement of the law, which hopefully you will recognize and can eliminate on that basis alone. So that's diversity jurisdiction in a nutshell, and some of the wrinkles that tend to be introduced in multiple choice questions. There is, of course, another basis for federal subject matter jurisdiction, and that is the presence of a federal question. When there is a federal question in the case, diversity is not required, so don't be tricked by questions that give you citizenship information or amount in controversy information together with federal question information. If there's a federal question, the rest of it doesn't apply. Federal question jurisdiction exists if the claim arises under the federal Constitution, federal statutes, or treaties, the last of those being less likely to come up. For most federal law issues, federal and state courts have concurrent jurisdiction, meaning that the suit can be heard by either a federal or a state court. In other words, generally, the plaintiff can choose. For a handful of issues, federal courts have exclusive jurisdiction, which means they can only be heard by a federal court, and the suit will be subject to dismissal in state court because the state court will lack subject matter jurisdiction over that case. Some of the most common areas of exclusive federal jurisdiction are admiralty, securities law, suits between two U.S. states, bankruptcy, patent, copyright, and federal trademark. State and common law trademark cases can be brought in state court, and antitrust. Remember, suits heard under federal question jurisdiction have no amount in controversy or state citizenship requirements. If a suit can be heard under federal question jurisdiction, supplemental state claims arising from a common nucleus of operative fact may also be heard, even without an independent jurisdictional basis in federal question or diversity. In other words, they are supplemental to the federal question, but their determination rests upon a common nucleus of operative fact, and so, basically as a policy matter, the idea is the suit has a right to be there in federal court, and the federal court is competent to decide these related state court matters because they arise from a common nucleus of operative fact. We have a sample question. Question number 4. The owner of a copyrighted image of a cartoon character sues a t-shirt manufacturer, incorporated and having its principal place of business in Alabama, for copyright infringement relating to a line of t-shirts. The copyright owner, domiciled in Tennessee, seeks $50,000 in damages for the copyright infringement claim and also a breach of contract claim, alleging that the t-shirt manufacturer did not pay the agreed-upon licensing fee and also put the image on hats and bags in violation of the license terms. The suit is filed in federal district court. The t-shirt manufacturer seeks to dismiss the case, should the motion be granted. So, a first thing to notice about this question is it's a yes because, no because kind of structure. The second thing to notice is you are given very little information about the basis of the motion to dismiss. You are expected to see that the first basis for any motion to dismiss in federal court is 12b1, lack of subject matter jurisdiction, and to assess whether subject matter jurisdiction is present here. This is an example of a question in which you are given facts relevant to both forms of federal subject matter jurisdiction, diversity and federal question, and there is satisfaction of one, but not the other. So you're given the states, the relevant states, Alabama and Tennessee. There's complete diversity of citizenship, but the amount in controversy is clearly insufficient. If the only basis were diversity jurisdiction, it wouldn't work. On the other hand, there's another basis of subject matter jurisdiction, copyright infringement, and that is one of the claims that is on our list of exclusive matters of federal subject matter jurisdiction. So it's not just that there is a federal question there, right, which might be the case with many cases where there's concurrent jurisdiction, but that this case actually must be brought in federal court. The slight additional wrinkle is that in addition to copyright infringement, there is an ordinary, so-called garden variety, breach of contract claim, right? And that claim, it's true, it relates to the underlying copyright license for the t-shirts and the hats and so forth. It is not itself a federal question. It is certainly not an area of exclusive federal jurisdiction. Diversity is not met with respect to it because of the amount of controversy issue. Standing alone, it would be insufficient, but it's now attached to this copyright infringement claim as an example of supplemental jurisdiction. So can this defendant get this suit dismissed out of federal court? He cannot. There's a federal question here. So let's look at the answers on the no side. No, because the case presents a federal question. No, because the requirements of diversity jurisdiction are met. This is easy, right? This is a federal question, indeed a matter of exclusive federal subject matter jurisdiction, so A is our correct answer. But let's say Your intuitions are not as good, you're not sure, you don't remember all of those rules. Let's read through the other answers. Should the motion be granted, that is the motion to dismiss brought by our defendant? Answer C, yes, as to the breach of contract claim, because the court lacks jurisdiction over that claim. As I discussed before, if that claim were standing alone, that answer would be right. And if you mistakenly believe that each and every claim in the case must have an independent basis of federal subject matter jurisdiction in diversity or federal question, you might be attracted to that answer. But if you remember that there is such a thing as supplemental jurisdiction, that supplemental jurisdiction is provided for by its own statute, 1367, then that statute provides a basis of subject matter jurisdiction for a supplemental claim of this type. And then finally, answer D is just the outright dismissal because there's no federal subject matter jurisdiction. And that, I would hope, is an answer that would not be appealing to you because you would remember, even if you didn't remember, that copyright matters are matters of exclusive federal jurisdiction, that you would at least remember that it is a federal law, it's in the Constitution, and so was properly heard by a federal court. The next of our subjects concerns remand and removal. Later potential stages in a jurisdictional dispute that relate to whether there is or is not federal subject matter jurisdiction and can come up in a couple of different settings. There are some easy places to avoid making tempting mistakes here if you're very careful as a reader, but also some slightly more complicated rules that you need to understand. Removal and remand can be thought of as counterpart concepts because the case is moving in opposite directions with respect to federal and state court. A case initially filed in state court can be removed by a non-local defendant only if federal jurisdiction is present. In other words, if the case could originally have been filed in federal court. So that's movement from state court to federal court by a defendant who is not a domiciliary of the forum state. Removal is always and necessarily to the federal district court that includes the place where the state action began. This is simple if you're in one of those states that itself is only a single federal district. If there are more than one federal district, again, it's not going to come up in your MBE question, that is removal to the wrong federal district court. The removal happens to the federal district court that encompasses the territorial area of the state court in which the action began. A case initially filed in state court and then removed may be remanded, which is to say sent back to state court, if the court determines that federal subject matter jurisdiction is lacking. A federal court must remand if there is no original federal subject matter jurisdiction. That is, the removal itself was jurisdictionally improper. The remand must result. But a federal court also may remand, even if there is federal subject matter jurisdiction, under certain circumstances, of which the most common are when complex issues, especially complex undecided issues of state law predominate. That's what the case is really about. Or, for example, if state regulatory proceedings are ongoing in a way in which the federal suit might interfere and not helpfully. Right? State courts are generally regarded as having greater expertise on matters of state law, and if that's what the case is really about, even if, for example, there is diversity of citizenship and the amount in controversy is met, and hence the removal is in that sense technically proper, the federal court may decline to exercise the subject matter jurisdiction that it has and remand the case back to the state court in which it began. But remember, and this is an easy mistake to make, a case not initially filed in state court cannot be remanded back to it. It will simply be dismissed and eligible for being filed initially in state court. In other words, be sure you don't make the mistake of thinking that a federal case begun in federal court can be sent back, as it were, to a state court that had never heard of it before. Right? The federal courts do not have that power with respect to the state courts. The federal court will be remanding back to state court only cases that have been improperly removed as a technical matter. That is, there is in fact no federal subject matter jurisdiction. Had the case originally been filed in federal court, it would have been subject to a 12b1 dismissal. Or, even in the presence of federal subject matter jurisdiction, not exclusive federal subject matter jurisdiction, but typically concurrent federal subject matter jurisdiction on a federal question, or a properly pleaded diversity case, the federal court may nevertheless decline to exercise its subject matter jurisdiction and send the case back to the state court from which it came because complex issues of state law predominate, especially if those issues are undecided, or there are ongoing state regulatory proceedings in which the federal court does not wish to interfere. Here's our sample question. A plaintiff domiciled in Michigan files a tort suit in Florida state court against a defendant domiciled there. If we jump ahead to the call of the question, if the court remands this case, what is the most likely reason? That's what reminds us, remember our subject is federal civil procedure. When you start this question, you're hearing about a case being filed in state court. That might lead you to think it's about a different subject matter area than federal civil procedure. But if you look ahead and see the court remanding, then you know there's a removal coming and we're in a removal remand situation. The claim contains two causes of action, one for fraud, for which the plaintiff seeks $50,000, and one under a tort recognized only by Florida, about which Florida has a well-developed jurisprudence. The plaintiff seeks $40,000 in damages arising from the Florida tort, and the defendant removes. So we have, again, now we're dealing with a diversity case. So determining whether a removal is technically proper is just like doing an initial subject matter jurisdiction analysis. There's no federal question issue in here. It's clearly being removed on the basis of diversity. We have a Michigan plaintiff, maybe a Michigan defendant. Plaintiff domiciled in Michigan files a tort suit in Florida against a defendant domiciled there. Defendant domiciled in Florida. We start in state court in Florida. There is a total of $90,000 in issue, so the amount in controversy is met, right? If this suit had begun in federal court, it appears to be proper. That is, we have complete diversity of citizenship, and we have a $50,000 claim plus a $40,000 claim, and as you may recall, a plaintiff is allowed to aggregate their claims against a single defendant to meet the amount in controversy. So far, so good. But this court is going to remand because when removing from state to federal court, non-local defendants are not given access to that remedy. In other words, although it would have been proper to file this initially in federal court, it's not proper to remove it there because of this local defendant rule. If the court remands, what's the reason? What we're going to be looking for in our answer is something about that local defendant and the impropriety of a local defendant removing from state to federal court. We read through our answers one at a time because this is a most likely reason type of question, not a yes because, no because type of question. A, the amount in controversy requirement cannot be met by aggregating distinct claims. But that's false. As you may recall, this is okay. False statement of the law. B, issues of state law will inevitably predominate. Now this is an interesting one because this is a possibly right answer if it weren't for this. We have the second claim, a tort recognized only in Florida. It's not most of the damages, but it might be more complicated, right? That's at least possibly it's in the running. C, the Florida federal court is not competent to hear a tort recognized only in Florida. That's false. Federal courts are competent to hear any ordinary tort claim. There are some exceptions to federal subject matter jurisdiction even when diversity requirements are met, but a tort recognized by only one jurisdiction is not one of them, so we can eliminate that answer. And finally, D, a Florida defendant cannot remove from Florida State Court to Florida Federal District Court. And that is our right answer. That's the local defendant rule, and so that one is the stronger answer. That brings us to the end of our federal subject matter jurisdiction discussion, and we will turn our attention now to 12b-2 and the personal jurisdiction of the Federal District Court over every defendant hailed into court there. As we have seen, subject matter jurisdiction focuses on the power or authority of a court to hear a particular type of case. The question is whether this case, these claims, can be adjudicated by a federal district court. And a case must meet the statutory requirements, as we have seen, or it will be subject to dismissal or remand, as the case may be. Personal jurisdiction, on the other hand, focuses on whether this defendant can, under the U.S. Constitution, be held to answer for this claim in this court, or as it is sometimes put in more traditional language, hailed into court. Can this defendant constitutionally be hailed into court on this claim? There are a few easy cases of personal jurisdiction. So these are ones you want to just be able to recognize instantly. They don't require any special analysis. In-state defendants, those domiciled in the forum, can always be sued there on every type of claim. Out-of-state defendants, personally served in the forum, so long as the defendant is voluntarily there for any reason. We can think of this, once we move into the minimum contacts area, as the so-called magic contact or gotcha jurisdiction. That is, the defendant personally served in the forum where they are present voluntarily, although domiciled elsewhere, can still be hailed into court in the forum on any claim. Defendants who consent in advance with a forum selection clause or afterwards, either by appearing and not contesting jurisdiction or by answering a claim without raising a jurisdictional defense, cannot do so later. Unlike subject matter jurisdiction, the absence of which is a defect fatal to the claim, even if it never shows up until the case is before the U.S. Supreme Court, personal jurisdiction, 12b-2, is a use-it-or-lose-it defense. If it is not raised at the first opportunity, it is lost forever. So a defendant might potentially consent in advance to the exercise of a particular jurisdiction's courts over him or her, for example, with a forum selection clause in a contract, or alternatively may lose the right to contest personal jurisdiction by appearing or answering without raising the defect. Even if a state could not otherwise constitutionally exercise personal jurisdiction over a defendant, personal service in the forum or consent suffice. Again, this is use it or lose it. It is not the kind of fatal defect that 12b-1 is intended to point to. Question 6. Defendant, a domiciliary of South Carolina, is personally served with a summons and complaint relating to a suit filed against him in Missouri by a Missouri domiciliary. The suit alleges a breach of contract. The contract was not signed in Missouri, nor has defendant ever done business there, nor any contract-related activities to be performed there. Which of the facts, if it alone were true, would most weaken defendant's motion to dismiss for lack of personal jurisdiction? So the first remark I want to make about a question of this type is it is logically a little bit complicated. It's more complicated than yes because, no because, no because, and logically in its internal structure a little more complicated than what's the best reason, what's the likeliest outcome, which kind of requires a single track of analysis. This kind of a question, you want to make sure that you remember what you're looking for, and you may want to jot something down in the margin when you're working through these materials and even when you're taking the bar exam to remind you what you are looking for. Reading these facts, we know the defendant's motion to dismiss for lack of personal jurisdiction is coming, right? And the question is which of these facts weakens the motion to dismiss. Put another way, the question is, which of these facts strengthens the claim of personal jurisdiction the most? Okay? So we're looking for the fact that makes the assertion of personal jurisdiction over this South Carolina domiciliary in Missouri the easiest to establish. Right? That is, which helps the Missouri court the most, or helps the Missouri plaintiff the most in their attempt to get this person hailed into court in Missouri, which helps the most. The suit seeks $50,000 in damages? No, irrelevant. Defendant was domiciled in Missouri when the contract was signed. That's not bad, right? It might help, right? At least a little bit. It certainly favors the exercise of personal jurisdiction over this defendant by a Missouri court, right? It might be our best answer. That's going to depend on what's coming. C, the contract includes a forum selection clause identifying Missouri as the forum. Now that is a slam dunk, right? If we're not told anything about defects in the contract that would force the forum selection clause to fall with the contract as a whole, in this case, the assertion of jurisdiction is now incontrovertible, right? Unstoppable. So C is certainly a better answer than B, though by this point we want to read all our answers just so we know. D, defendant, an enlisted serviceman, was served while on a military base in Missouri to which he had been assigned. So this is only going to be a tempting answer for someone who doesn't remember that in order for service in the forum to have the effect of establishing personal jurisdiction, the defendant must voluntarily be there. Not just physically be there, voluntarily be there. This is not an example of someone who is voluntarily there, and so C is our superior answer. In determining whether the exercise of personal jurisdiction over a particular defendant comports with the Constitution, there is a second piece of analysis that we have to do. Not only must every exercise of personal jurisdiction be constitutional under some principles that we will be discussing, but it also must be permitted by the state's so-called Longarm statute. So every state in the United States has a statute that allows for the exercise of jurisdiction by that state's courts over non-domiciliaries. There are two different styles of such statutes. One is what we would call an enumerating statute. An enumerating statute permits jurisdiction to be exercised over non-domiciliaries under listed circumstances. The other kind of statute simply permits the state courts to exercise jurisdiction under any circumstances not incompatible with the U.S. Constitution, thus collapsing the state's Longarm statute into a constitutional analysis. An enumerating statute can give a state less jurisdiction over fewer possible defendants than the Constitution might allow. That is, a state might choose to be, as it were, modest in its assertion of personal jurisdiction over out-of-state defendants. If, by contrast, a state is overly aggressive in the out-of-state domiciliaries over which it purports to be able to obtain personal jurisdiction, it will be cut back by the Constitution. In other words, you always have to satisfy both, regardless of whether it's an enumerating statute or a to the limit of the Constitution statute, and regardless of whether the state statute purports to give the state more than the U.S. Constitution does, because that's not allowed. However, if the state only chooses to exercise jurisdiction over a subset of those defendants that the Constitution would permit personal jurisdiction over, then a 12b2 motion will be appropriate if the state's enumerating statute does not include this particular defendant. So you have to read such a statute with care if there is one in the problem. Most of the time, however, the state statutes conferring jurisdiction on out-of-state defendants are specifically drafted to permit jurisdiction to to the limit of what the U.S. Constitution will permit. So although it's a two-step analysis, the substance of those two steps is collapsed into one. Anytime jurisdiction would be proper under the U.S. Constitution, it would, a fortiori, also be proper under that state's Longarm statute, which permits jurisdiction to the limit of the Constitution. The basic guiding idea of U.S. constitutional jurisprudence in this area is to determine, setting aside the list of automatic ways you can get personal jurisdiction over a defendant, that form of contact between the potential defendant and the forum state that ensures that an exercise of personal jurisdiction over that defendant comports with what the U.S. Supreme Court has called traditional notions of fair play and substantial justice, and some of the meat that has been put on those perhaps rather abstract bones is the notion of minimum contacts. Does the defendant have sufficient minimum contacts with the forum state that an exercise of personal jurisdiction over him is fair? Right? That's a rough and ready way to put it. So, when trying to establish this, the good news is the bar examiners are not going to give you, in a multiple choice setting, an extremely difficult gray area case in which it is very difficult to tell whether a federal court has jurisdiction or not. They're just not going to do it. That is not what you're going to be called upon to do in a multiple choice kind of situation. In an essay question, maybe, right, you might have to evaluate, right, it might be a right on the line kind of case, but in a multiple choice question, they're typically going to give you facts that closely track one or another of the leading constitutional cases in this area, and which, if you recognize them, it'll be pretty easy to see that the minimum contact standard has been satisfied. So here are some of the things to look for without going through those cases, which I hope it's safe to say you've gone over in some detail in other substantive reviews in this area, and that were hammered home pretty heavily in the civil procedure class that you took as a law student. So here are things to look for in the facts and in the answer choices. Substantial and continuous activity within the state, especially where you're talking about a business activity of a business defendant and a business claim. If there is enough such activity, it may be that jurisdiction would be proper even on an unrelated claim. This is something that is called general jurisdiction. Much less commonly asserted, but it is something whose existence you want to be aware of. Purposeful availment of the benefits and protections of the state and its laws. The claim arises out of the defendant's activities within the state. That is, claim-related contacts. Claim-related contacts are especially important. If the events that give rise to the claim happened in a state, it's much likelier that you can sue the defendant there than trying to base it on unrelated contacts. A foreseeable injury suffered in the state. And finally, fairness to the non-resident defendant, including convenience to the parties, the forum state's interest in the case, and the relationship between the contact and the claim. These are things, these last, which are much likelier to show up in an essay format because they're much more diffuse, less obvious which way they point. There may be facts pointing both directions. Question 7. While driving through Nebraska, an Ohio driver struck and killed a Nebraska pedestrian. The family of the pedestrian brought a wrongful death suit against the driver in Nebraska Federal District Court, seeking $100,000 in damages. So you do want to be having some bells go off in your head about diversity jurisdiction, and you should see it's readily satisfied here. It's a Nebraska pedestrian, it's an Ohio driver, $100,000 in damages. That part's easy. The wrongful death suit is an ordinary tort claim. It's not a federal question, but that's not a problem. Nebraska has a Longarm statute that provides that personal jurisdiction over out-of-state defendants is permissible only for those defendants personally served in the state or who enter into contracts or do business in the state. That is an example of an enumerating Longarm statute that is considerably more modest than the Constitution itself. You might notice that there is no mention in that Longarm statute of tort claims arising from defendants' conduct in the state, right? And you might have to reread it and be careful. right, just so that you see the scope of that Longarm statute. Defendants personally served in the state, we know that, that's the magic contact, who enter into contracts, that is not tort, or do business in the state, this is not a business-related event. The driver files a motion to dismiss based on lack of personal jurisdiction. If the motion is granted, what is the most likely reason why? And I hope you see that the most likely reason is that we are in one of those situations in which this, if we think of this as jurisdiction as permitted, right, personal jurisdiction permitted by the Constitution, is this, the enumerating statute, right? This is the state enumerating statute. And it's of the style that I have described as modest. It's the modest state enumerating statute because of this. And this is where this conduct took place. If it's anything, it's a tort, right? It's a wrongful death suit. Driver files a motion to dismiss, and he prevails because he is in this area. So let's see the answer that best reflects that. A single contact with Nebraska is insufficient to satisfy minimum contacts. That's false, as we know. There's the magic contact, and there's also a claim-related contact. If the contact is the thing from which the claim arises, that could be enough. And that's true here, right? So this is a false statement of law that also does not fit well with the facts. B, the defendant has not purposefully availed himself of the benefits and protections of Nebraska law. Well, that's maybe true, maybe false. Some courts have held that driving on the highways of a state is purposefully availing yourself, but maybe not. It's not clear this person's on a highway. They're driving through. We don't know exactly. So, in addition, that is not the sole test. C, non-compliance with the state Longarm statute, right? As our analysis has shown, that's the right answer. Now, maybe in getting ready to answer this question, you would not have done this analysis initially. Of course, I knew what was coming, but you wouldn't necessarily on the MBE. But when you encounter that answer C, that should drive you back into the question and its facts, which will then point this out, right? You'll look at that enumerating statute and realize, wow, right, the tort-related contact is not in that enumerating statute, and therefore that's a good answer. For the sake of completeness, we'll look at the last. Service did not take place in Nebraska. True, but not relevant, right? That is not by itself a basis for a motion to dismiss, because if the enumerating statute were met, it wouldn't be required that the service take place there. Just a few words about venue, rarely examined in the MBE context, but you also want to be able to recognize wrong answers that might arise from it. The specific choice of venue that's dictated by the U.S. Code is not a heavily bar-examined subject. It's very technical and, in a way, kind of too small, right, to show up on the MBE, but it's possible that it might show up as parts of potentially wrong answers, so you don't want to be misled by it. So just so you know, and just to remind you, not only must the federal district court have subject matter jurisdiction over the case and personal jurisdiction over each and every defendant, we also must be in the right venue, that is, the right particular federal district within the state. Of course, sometimes that's easy because the state is one of those one-district states. There are lots of them. But there are also many states that have 2, 3, or as many as 4 districts. That's the maximum. And if you are in the wrong federal district, but in the right state, that is, the personal jurisdictional analysis is a state-by-state analysis, but venue is a district-by-district analysis, then a transfer may be proper. Venue is proper under the federal code in the venue where, that is, the federal district where, all the defendants reside, if there is one, a substantial part of the claim arose, a substantial part of the property is located, if that's the sort of claim it is, and if none of those can be satisfied in any district where any of the defendants, if we have multiple defendants, is subject to personal jurisdiction. So if you have only one defendant, the proper venue, if you have one defendant and that defendant is local, the proper venue will be the district in which that defendant resides. If you have multiple defendants who reside in different districts of that same state, but that state can exercise jurisdiction over all of them, then any district where any defendant is subject to personal jurisdiction will be a proper venue. Two different situations may give rise to a motion for change of venue. First, if the original venue was improper, and second, when there is a better, more convenient venue for the resolution of the claim. That is, even if the first venue is proper. Right? So, if the original venue is improper, you must find a proper venue. But even if it is proper, there may be a better venue. Right? So those are different, and there's a different standard for the granting of a motion if you're initially in an improper venue versus if you're initially in a proper venue, but there might be a still better one. Forum nonconvenience is one of the very few Latin terms or concepts, or rather concept expressed in a Latinate form, that you do want to know and be able to recognize for the bar exam. The basic standard implicated by forum nonconvenience is that the forum court, that is the court where we begin, may, for the convenience of the parties and witnesses and in the interests of justice, transfer the case to another federal district where it could originally have been brought. And this is now codified by statute through transfer venue or change of venue. So that's the situation where we are going from improper venue to proper venue, or proper venue to better venue. But in both cases, the transferee venue, the place where the case ends up, must be a venue that would have been proper as the original venue. Outright dismissal is also occasionally, rarely available, right? That is complete dismissal of the case out of the federal system in contemplation of the case being filed outside the United States entirely. That is, the idea of forum nonconvenience of that form is that there is a superior forum outside the United States entirely. There are 6 factors used by a court in determining a forum nonconvenience change of venue with which you want to be familiar. The convenience of the parties, including the ability to join necessary parties and obtain jurisdiction over them. The convenience of the witnesses, their availability, the subpoena power of the court, the location of the evidence. The state interest in retaining the case, which is often tied to having a forum domiciliary plaintiff. This would be the case where the suggested transfer is not to another district of the same state, but to a federal district of a different state. Will our original forum have a state interest in retaining the case? Whether the laws of the alternative forum, that is the would-be transferee forum, will impair a substantial right of the plaintiff, that's only going to happen where a change of venue will result in a change of law, which is rare. That opens things out into choice of law issues that are beyond the scope of the MBE, but just be aware most of the time that a change of venue within the federal system will not result in a change of law, so that would be unusual. A foreign court's interest in resolving the dispute, if there's a foreign domiciliary in the case, and so on, and the availability of an alternative forum, which of course is essential if we're talking about a transfer, because it would have to be a transfer inside the federal system. So now we have an example question. Number 8. A Hawaii domiciliary is injured when her food processor explodes, spattering hot soup all over her. She sues the manufacturer, incorporated and having its principal place of business in South Dakota, in Hawaii Federal District Court. Right? So, since we know this question is about venue, but when you're reading along while taking the exam, that might not be so obvious. We'll leave that. Because when you're given all these states, you need to be thinking diversity jurisdiction. So here, we have our Hawaii plaintiff, domiciliary, who sues the manufacturer, incorporated and having its principal place of business in South Dakota, for both incorporation and principal place of business. They're diverse. At a glance, you can see that the question does not mention any dollar figure, and that tells you right away it's not going to be a subject matter jurisdiction question because you're just not going to be given enough facts. Or maybe if it is that kind of question, that would show up in the answer, but looking in the answers, we see no numbers and no dollar signs. The food processors are sold in stores in every state and through online retailers. As you're reading that, you might think personal jurisdiction. Is there going to be a problem getting personal jurisdiction? Has there been purposeful availment? Have they directed their products they put their products in the stream of commerce intending them to get to Hawaii? Is it fortuitous, etc.? She also, so we've got another defendant coming in, she also sues the designer of the food processor, an engineering company incorporated and having its principal place of business in North Dakota. So we have another incorporated and principal place of business, right? And again, think about, can we get personal jurisdiction over them in Hawaii, right? The witnesses and evidence relating to defective design are all located in North Dakota. And just to make life easy, each of these states has just one district. So we're not going to be worried about venue in terms of multiple districts within a single state. Okay? So we've got witnesses and evidence here. Okay? It's possible we can get personal jurisdiction over this defendant here. Not so easy to get personal jurisdiction over this defendant. We're in Hawaii Federal District Court. The defendants seek dismissal for lack of personal jurisdiction. So our question might be about that. Or in the alternative, a change of venue. Okay. So you've been given facts here that suggest what might be a superior venue. Right? This is the troubling defendant. This is the defendant where the case for personal jurisdiction is going to be tougher because it's not clear that they have any of the right kinds of contacts with Hawaii. By the same token, however, it's clear that if you can get this case into North Dakota, you'll have personal jurisdiction over this defendant. We know this defendant puts their products into the stream of commerce everywhere, right? And so there won't be a personal jurisdictional problem there, and it appears no venue problem because North Dakota will be a district in which you can obtain personal jurisdiction over our North Dakota defendant. So what we're going to be looking for is an answer that takes us there. So let's read through them. Though this is yes because, no because, no because, right? Is the motion likely to be granted? Okay. Or it's partly that structure. A, yes, and the case will be dismissed. So that's going a long way, right? If we were just thinking about personal jurisdiction, North Dakota defendant might be able to get out, right? As we'll see when we talk about necessary and indispensable parties. If the North Dakota defendant is indispensable, we're not going to be able to proceed with this case in Hawaii. If this were just about personal jurisdiction, we might get that outcome. But we have the alternative of the change of venue, so let's continue. B, the motion to dismiss will be denied and the case may be transferred to North Dakota. All right, that looks good. Let's see if there's a better answer. No, because venue was proper in Hawaii. But that's not a complete answer because we also face this personal jurisdictional issue with respect to our North Dakota defendant. And D, no, both motions will be denied. So then we're choosing, I think, between B and D, and the facts have been loaded up to give you a reason to think North Dakota is the right place, making that the superior answer. So that's it for subject matter jurisdiction, personal jurisdiction, and venue. Now we'll move on, although we won't spend too much time because it's not a heavily multiple choice bar examined kind of subject, to that part of the Erie Doctrine that you do need to know and have some familiarity with for MBE purposes. So the Erie Doctrine is potentially exceedingly complicated. You might have had a very difficult first-year exam question on it, or may remember it only in a haze, although I hope it's been refreshed by your substantive review of this subject. But for MBE purposes, we can boil it down really just to its essence. The basic idea of the Erie Doctrine is to eliminate or reduce incentives for forum shopping as between state and federal court, with the same case, right? So a plaintiff who could potentially sue on the very same claim, same defendants, in either state or federal court, right, should not be encouraged to choose between state and federal court on the basis of the substantive law that will be used to decide the case. In other words, whether the party sues in state or federal court, the substantive law used to adjudicate the claim should be the same. But each court will be using its own procedure. So, sounds simple so far. State courts will use state procedure. Federal courts will use the federal rules of civil procedure, but the same substantive law will govern the case. The basic rule of Erie, therefore, is that a federal court sitting in diversity will apply state substantive law and federal procedural law. Again, the second half, generally obvious. Nobody would expect a federal court to be using state procedure. It's the state substantive law that's the important part. And the complicated part can sometimes be the determination of whether a particular issue is, as is described in the literature, substantive or procedural for Erie purposes. And the best way to think about this, and again, it's not a subject that needs to take up a lot of your bar exam studying time. When I actually teach this in first year civil procedure, we spend a good deal of time on it, but now we're just recapping, is that this notion of substantive or procedural, you really want in this context to think of as substantive or procedural for Erie purposes. Because some things which are substantive for Erie purposes or procedural for Erie purposes might not seem so substantive or procedural for other purposes. That is, something might be substantive for Erie purposes that otherwise seems just to be a procedural rule or law, and you just have to learn it. Probably among the paradigm case of that is that the U.S. Supreme Court has held that a state's statute of limitations is substantive for Erie purposes. In other words, a state statute of limitations on a state claim will travel with the claim into federal court and apply in federal court, even if the federal court would apply a different statute of limitations to a similar claim. In addition, the other one that can be sometimes tricky to remember is that choice of law, that is a state's choice of law rules, are substantive for Erie purposes, even though often thought of as an utterly procedural question. That is, in a situation in which the laws of the forum might apply or the laws of another state might apply, a state has rules, choice of law rules, to tell the state's courts which law applies. That might seem to be an archetype of a procedural rule, which state's law applies. Nevertheless, choice of law is substantive for Erie purposes. That's the so-called Claxon doctrine, which you may or may not have learned in first year civil procedure. That is Erie and Claxon, which results in state choice of law rules being treated as substantive for Erie purposes to ensure that whatever substantive law the state court would apply, which might be its own law, but might not be, will be the same law applied by a federal court sitting in diversity in that state. So we've got a couple questions that are designed to lock that in. Question 9. A retailer incorporated in the state of Washington and having its principal place of business there entered into a $100,000 contract with an Idaho supplier of goods. So, we have states identified, so it might be a diversity question of some kind. And of course, the Erie doctrine is a diversity doctrine, right? And so another way of thinking about it is as a further articulation of all of the rules that govern diversity cases. The supplier failed to deliver, and the retailer brought a suit for breach of contract in federal district court in Ohio. So retailer, Washington, other contracting party, Idaho, brought suit for breach of contract in federal district court in Idaho. So we have no personal jurisdictional issues. We're in the defendant's home state. This is not a removal case. We start in federal district court. The amount in controversy is more than met. It's a $100,000 suit. So far, so good. Idaho's statute of limitations for breach of contract is 3 years. Washington's statute of limitations for breach of contract is 5 years. The suit, of course, was filed 4 years after the alleged breach. In other words, too late under Idaho rules, but timely under Washington rules. If the supplier, our defendant, seeks a dismissal arguing that the suit is time barred, will the supplier prevail? So there are a few different ways of coming at this, right? But I hope you see the issue. The issue is Does the Washington plaintiff get the benefit of Washington's longer statute of limitations, right? Or are they limited by the Idaho shorter statute of limitations? So for this, because it's complicated and implicates Erie, we may want to read through all the answers, right, to see which one states the rule correctly, as much as developing our own intuitions on yes, no. Okay? So, A. Remember, the question is, if the supplier seeks a dismissal arguing that the suit is time barred, right, what happens? Does the supplier prevail? Yes. Because the forum state will always apply its own statute of limitations. Now, that might seem tempting after what I just said, right, that statutes of limitations are substantive for Erie purposes. However, the question is not whether the forum state will apply its own statute of limitations, but whether the forum state's choice of law rules direct it to apply its own, in this case, shorter statute of limitations. So that's an overstatement. It's not grossly wrong, but there is certainly a better way to state the rule. Let's see if it's coming. B. Yes, unless Idaho's choice of law approach directs the application of Washington's statute of limitations. Now that is an answer that much more correctly states the rule, right? It's a yes unless, right? And so there might be a no answer that states the rule even more precisely, but B is certainly superior to A. C, no unless the federal court chooses in its discretion to apply the Idaho statute of limitations. Well, I hope that one jumps out at you as obviously wrong. The federal court, under the Erie Doctrine, where statutes of limitations is concerned, has no such discretion. That's simply a false statement of the law. And then D, no, that is no, the motion to dismiss is not granted, because the federal court will apply the longer of conflicting statutes of limitations to protect the interests of a non-domiciliary plaintiff from discrimination. Might sound good as a policy, but it's not the law. So the best answer is B. Question 10. A Florida domiciliary was injured in an automobile accident in Florida when she was struck by a Georgia driver. Treatment for her injuries cost $50,000, and her lost wages from being unable to work also totaled $50,000. So we've got a Florida domiciliary who's going to be suing a Georgia domiciliary over events that took place in Florida, and so she's going to have a choice. She could sue in Florida and obtain jurisdiction based on claim-related contacts, or she could sue in Georgia, her defendant's state of domicile. Rules for service of process under Georgia law were easier and cheaper to comply with than the state service of process rules under Florida law or the federal rules of civil procedure. If she wishes to have the benefit of the Georgia service of process rules, where should she file her claim? So these are facts that could potentially give rise to a pretty hard question, but this is not that question. This is an easy question. If you want state service of process rules, clearly procedural, you must be in the state court that uses those rules, and that's letter A, the state court in Georgia. The rest of these are answers that will only be appealing if, for some reason, you're not clear on whether service of process is procedural. A good way to remember that it is that there are federal rules of civil procedure about service of process, and the coordinating basis for dismissal, 12b4 or 12b5. Onward to the pleading dimensions of civil procedure, rather than the early service dimensions. And notice, I'm not going to spend a lot of time, nor will we in these materials spend a lot of time, on 12b4 and 12b5. They're not common, right? This Erie dimension is pretty much the only one I think that is at all likely to be tested, as opposed to sort of the intricacies of proper service and proper process as required to avoid a 12b4 or 5 dismissal. Moving on to Rule 8. Rule 8A requires notice pleading, meaning that the plaintiff must merely allege sufficient facts to put the defendant on notice of the cause of action, not specific facts relating to each element of each claim, and so on. unless it's one of those special claims that must be pleaded with greater specificity, such as fraud and mistake under Rule 9. The Federal Rules of Civil Procedure also generously permit amendment of pleadings to add new claims if they relate back to the original complaint, and new parties also, with the caveat that if the plaintiff seeks to add new parties after the statute of limitations has run, this is permitted only if the new defendant had actual knowledge of the suit before that time and knew that he or she was the defendant who should have been sued. Just so that you know, DOE defendants, fictitious defendants, are not permitted in diversity cases, and so you can't sue at the close of the statute of limitations with DOE defendants in federal court and then later substitute in the proper parties. So, question 11, will the Indiana driver's motion to amend the complaint be granted? So this is a motion to amend. We have a general rule that generously allows amendment of pleadings, so we're going to read to see whether this is a situation in which amendment of pleadings is likely to be allowed on all the bases or with respect to all the matters on which an amendment is sought. An Indiana driver gets into a highway collision with a semi-truck with Illinois license plates. The side of the truck says Illinois haulers and has a phone number. The Indiana driver's car is totaled and he also suffers personal injuries. Not long before the applicable statutes of limitation expire, he files suit in federal district court in Illinois. So we have an Indiana driver suing. My apologies. We have an Indiana driver suing in Illinois. That's our forum. Against an entity called Illinois Haulers, Inc., whose business address in Illinois matches the phone number on the side of the truck. So he believes he is suing an Illinois defendant. In fact, the truck was recently sold to a different Illinois shipping company. So he has an Illinois defendant, but it's not the entity he thinks it is. The actual owner of the truck is Chicago Shippers. When Illinois Haulers receives the summons and complaint, they pass the documents along to Chicago Shippers. Why is that important? Because it constitutes actual notice to the correct defendant, and that's essential if you're going to want to amend the pleadings. And forget about the lawsuit. That is, Illinois Haulers sold this truck. They just forget about it. A few days before the deadline for filing an answer arrives, the statute of limitations on the personal injury and property damage actions expires, right? Because the action was filed so close to the statute of limitations that the statute of limitations runs out before the answer deadline does. The Indiana driver's attorney contacts Illinois Shippers a day before the answer is due, keeping in mind that the statute has already run, and learns about the sale of the truck. The Indiana driver seeks to amend its complaint to name Chicago Shippers as the defendant and to add claims relating to the damage to his car. Will the Indiana driver's motion to amend the complaint be permitted? So note, we have two different kinds of amendments sought here. One is to change the name of the defendant to the proper entity, so it's not just changing the name, but changing the defendant. And another is to add claims. Okay? Keeping in mind that there's generally a generous standard as to the claims so long as they arise from the same events and be given the notice pleading. Changing to add the claims should be easy. Changing the defendant, here what's crucial is whether the proper defendant had actual notice before the statute of limitations ran, which they did, and enough notice to know that they are the defendant who should have been sued, which they should know they bought the truck, it is now their truck, etc. Those requirements are met. So we want to look for an answer that says yes as to both. And yet that answer is C. So this is a little variation on yes, yes, no, no, because it's three yeses and a no. We have these two different claims, right? So you want to look for the best answer there. Our next topic is joinder. Joinder is not about additional claims. Joinder is about additional parties. And so when we're going to add additional parties, we need to be thinking about both jurisdiction over the claims having already been established. Will there be personal jurisdiction over the parties sought to be joined? And do they potentially destroy subject matter jurisdiction by destroying diversity? So following the filing of the initial pleading, there are a number of ways additional parties may become part of the lawsuit, and you want to distinguish them and recognize which ones apply in various situations. For most but not all forms of party joinder, the same transaction rule strictly applies. The party to be joined must have rights or liabilities arising from the same transaction or occurrence, and there must be common questions of operative fact. But you want to be able to distinguish compulsory joinder, permissive joinder, and intervention and impleader, the last two of which are also ways that parties can be joined. Also keep in mind that although the terms may sound synonymous, and to lay people I would say are synonymous, there is an important legal difference between a merely necessary and what is called an indispensable party. A necessary party is one who must be joined if feasible, meaning if there is jurisdiction, but whose joinder will not result in dismissal. Indispensable parties are those without whom the action cannot proceed, and so whose joinder will be ordered even if this subsequently requires dismissal for jurisdictional reasons, typically. So if a party is necessary, they are joined. If a party is necessary and indispensable, they're joined and the action is dismissed. So let's fill in our table. On the next page, we'll talk it through. So the first thing, we'll jump actually to column 3, and does the same transactional rule apply? The answer is yes as to 3 of the 4. The only one with respect to which the same transaction rule does not apply is intervention. Back to column 1. Who seeks the joinder, and is the joinder sought as to a plaintiff or a defendant? In compulsory joinder, the defendant is seeking to add another defendant. With respect to permissive joinder, it may be either side adding to either side. Intervention is a non-party seeking to join on either side. An impleader is a defendant seeking to add a defendant. So compulsory joinder and impleader both involve a defendant seeking to add another defendant, and it's important to be able to distinguish between those. Notice the same transaction rule also applies to both of them. So what's the difference between compulsory joinder and impleader? Easier in a way to start with impleader. With impleader, the third-party defendant, the defendant that our existing defendant seeks to join, is someone who would be liable for all or some part of the judgment the plaintiff might recover from our original defendant. In other words, the typical situation is an indemnity suit. Compulsory joinder is more complicated and has a more complicated test. With respect to compulsory joinder, the defendant must be necessary, may turn out to be indispensable, meaning either complete relief is not possible without that party, or the parties will be materially prejudiced without that party being present, or there is a risk of multiplicity of suits with duplicate or inconsistent results and resulting inefficiency, or the absent party's interest will be materially prejudiced if they are not joined. So that's a more complex test, obviously, and the notion of compulsory joinder is that this is an additional defendant that the plaintiff has left out, maybe in an attempt to create or preserve diversity, but who is absolutely essential to a just and efficient adjudication of the claim. The impleader is simply a matter of efficiency, because our defendant could always go after that other defendant for indemnity or contribution by a separate lawsuit in the event that the plaintiff prevailed. So it's not that same standard of necessity at all. With respect to the impleader, the jurisdictional issues you want to be aware of is that supplemental or ancillary jurisdiction will be available, and independent jurisdiction would be needed only for claims not transactionally related. So the issue is generally going to be subject matter jurisdiction available through supplemental or ancillary jurisdiction. By contrast, with compulsory joinder, the court must evaluate whether the joinder will destroy subject matter jurisdiction in the diversity situation I described, whether the court can obtain personal jurisdiction, and if that will require a dismissal, But generally, the federal court will be able to proceed if it can fashion a remedy that minimizes prejudice without dismissal. With respect to permissive joinder, there is no special test because there is a requirement of independent subject matter jurisdiction and a freestanding basis of personal jurisdiction over the defendant to be added. So let's put all of that to work, or some of it to work, in questions 12 and 13. Question 12, let's jump to the question. Will the motion to join the Connecticut company be granted? So someone is trying to join a company, so that will tell, that is join a company as a party, and so that's going to be a joinder question. We'll want to have a structure, and we'll refer to the tests if we need them. So a Connecticut consumer is injured by a kitchen machine, which also set her kitchen on fire. The company that that sold her the machine is incorporated, has its principal place of business in Vermont. Connecticut sues Vermont, where they're incorporated and have their principal place of business. She sues in federal district court in Vermont, seeking $85,000 in damages. So far, so good. The jurisdictional minimum is easily met, and the parties are completely diverse. The Vermont company seeks to join the company that manufactured and designed the machine, incorporated and having its principal place of business in Connecticut. So now the Vermonter is trying to add a Connecticut defendant. We can see immediately that the addition of this defendant will destroy diversity, and it might suggest, we don't need to run away with ourselves because the question doesn't ask this, it may suggest that the reason our original plaintiff didn't join the company that manufactured the machine that injured her is that she wanted to be in federal court and knew she couldn't be if she sued this Connecticut defendant. If the Vermont defendant can demonstrate that this party is necessary and indispensable, the court will order its joinder and then dismiss for lack of subject matter jurisdiction. They will not remand because this case did not begin in state court. But this case would be perfectly fine, right, pleaded and pursued in state court where diversity is not required. Will the motion to join the Connecticut company be granted? So now we have to figure out if this party is genuinely necessary. Is complete relief impossible without them? It's not clear. I mean, she certainly could recover from the other defendant alone. Will the parties be materially prejudiced without this party in the case? We think so, right? It's the Vermonter who is going to want to send the blame here, but won't be able to if that party is not in the case. Or alternatively, they will be prejudiced by the Vermont company's attempt to blame them when they would want to defend themselves and blame it on the Vermont company. In other words, they need to be in the lawsuit. So we look at our yes because choices. Yes, and the suit will be dismissed, right? Because diversity is destroyed. Or yes, because the Connecticut company is an indispensable party. B is true, but A is a better answer because it takes us all the way through to the result. C, just because we want to take a look at them, no, because joining the Connecticut company will deprive the federal court of jurisdiction. That's to fail to understand how the necessary and indispensable party rule works. It will deprive the federal court of jurisdiction, but that's not a reason not to grant the motion. The motion's granted and the suit is dismissed. And then D, no, because the Connecticut company is not a necessary party. So as between A and D, you actually have to make the determination of whether they are necessary. And this question is an example of one which is intended to make that easy, right? The Vermont defendant only sold her the machine, right? It's unlikely, without going too much into the details of tort law, that the thing that happened to the machine that resulted in it injuring her and setting her kitchen on fire was due to the negligence of the seller, right? Much likelier, or we certainly would want to figure out whether it was due to the negligence of the manufacturer and designer, right? The Connecticut non-diverse company. Question 13, an easy one, purely procedural, purely vocabulary. If we jump to the question, which of the following will be the most likely way to add the Massachusetts repair shop to the case? So this is something where our choices, right, our answer choices are the four ways of adding, and you simply need to know the difference between them. We'll check our facts. A New Hampshire driver is rear-ended on the highway in Massachusetts by a Massachusetts driver whose brakes failed. So we're going to have a New Hampshire plaintiff suing a Massachusetts defendant over the failed brakes. The New Hampshire driver's car is totaled. The driver sustains the serious injuries. The New Hampshire driver sues the Massachusetts driver, who believes the Massachusetts brake repair shop that worked on his brakes most recently should also be in the case. What's the most likely way to add? Right? Our Massachusetts defendant's theory of the case is the reason my brakes failed is because of the negligence of the Massachusetts brake shop. That's a classic impleader situation, right? They would be suing for contribution or believe they should be indemnified because someone else's negligence was the real cause of the accident. And hence our answer is D, the impleader. And now we turn our attention to the other kind of joinder of claims. As I warn here, be careful to distinguish the rules surrounding joinder of parties, right, discussed above, we just talked through it, with joinder of claims. The rules are different, and so is the terminology. So you always want to be paying attention to whether a plaintiff or defendant wishes to add or change the claims in the case versus changing the parties, that is the cast of characters in the case. There are 4 types of claims that may be joined to an existing complaint. So you want to start from the position that the claims in the case are already ones over which there is federal subject matter jurisdiction, and the defendants in the case are already parties with respect to whom there is personal jurisdiction. So what are the types of claims that can be added? Permissive claims, compulsory counterclaims, permissive counterclaims, and cross claims. And we'll talk about them by filling out another chart, which again, right, takes us through these different aspects of these different kinds of claims. The permissive, the compulsory, the permissive claims, compulsory, counterclaims, permissive counterclaims, and cross claims. So, permissive claims are claims brought by the plaintiff against the defendant. So, these are claims by the plaintiff against the defendant. So we have our initial claim. We assume there is subject matter jurisdiction over this claim, and there is personal jurisdiction over this defendant. And now the plaintiff wants to add a new claim against the defendant. Does the same transaction rule apply? No, but it depends on this basis of jurisdiction. If the basis of jurisdiction here is diversity, right, other claims against the same defendant can be added. If the basis of subject matter jurisdiction is federal question, then only claims with a common nucleus of operative fact can be added and will be covered by ancillary jurisdiction. Counterclaims are claims by the defendant against the plaintiff. These are additional claims. These are counterclaims. Okay? And counterclaims are of 2 types, compulsory and permissive. Again, alleged by our defendant against our plaintiff. Compulsory counterclaims are those arising from the same transaction. Failure to assert compulsory counterclaims will result in them being barred by the doctrine of res judicata in order to make sure that all the claims arising from the same transaction are adjudicated in a single case. Compulsory counterclaims are use it or lose it. That is, once the plaintiff has sued the defendant on claims arising from a particular transaction, any claims the defendant has arising from that same transaction are compulsory, and if not asserted, will be lost. With respect to permissive counterclaims, the same transaction rule does not apply. Let's say the defendant has some unrelated claims against the plaintiff. Can they be added? Yes, but they need an independent basis of subject matter jurisdiction. They cannot piggyback upon the underlying claims in the case. Cross claims require a slightly more complicated picture in which we have defendant 1 and defendant 2, both being sued by the same plaintiff. Here is our cross-claim. Can the cross-claim be added to the same lawsuit? Yes, so long as the same transaction rule applies. That is, unrelated claims between these two defendants that have nothing to do with the underlying claim from the plaintiff cannot be added. If it does, however, arise from the same transaction, the cross-claim can be added, and supplemental or ancillary jurisdiction will apply as appropriate. Keep in mind also that such cross-claims are never mandatory, that is, never compulsory, meaning that the failure to assert them in this action will not allow them to be barred by res judicata in a later action. It's always up to the defendant whether they wish to bring claims against another defendant, even those arising from the same transaction, or hold off and wait to see how it comes out. In other words, this defendant might believe they can prevail against the plaintiff and let this go, or maybe not. So it's up to that defendant. That's a plaintiff is the master of their claim situation. With respect to this cross-claim, our defendant number 1 is the plaintiff and enjoys those benefits. On to question 14 to give us an example of this. A department store in Kansas orders furniture on a regular basis from a furniture maker incorporated having its principal place of business in Nebraska. And one of the things you might notice in these questions, I really try to stick to it in these review questions, the bar exam does the same, is the parties are introduced to you in plaintiff-defendant order, not the other way around. Sometimes the facts won't permit it, but if they do, it's generally set up that way. So if you look ahead to the bottom of the paragraph, it's the Kansas department store suing for breach of contract in the Nebraska Federal District Court. So we have a Kansas plaintiff, we have a Nebraska defendant who has both they're both incorporated and having their principal place of business here. You might notice at a glance that there's no money mentioned, and so this is not going to be about whether there is diversity jurisdiction. It's going to be about something else. Kansas department store and the Nebraska furniture maker enter into a contract for 150 leather couches to be delivered no later than December 1st, 2013 for the holiday season. The Nebraska furniture maker fails to deliver. Kansas department store sues. Which of the following claims must also be brought, right, or it will be barred in any subsequent suit? So what you want to be thinking of are which are mandatory claims, right? And the only ones that are mandatory are same transaction or occurrence compulsory counterclaims. So that's what you're looking for. A claim by the Nebraska party, right, against the Kansas party. So which are those? We have 2, A and C. Claim by the Nebraska furniture maker against its overseas leather supplier? No, that would be an impleader, right? Never compulsory, though they could do it, but it won't be barred if they fail to do it. C, claim by the Nebraska furniture maker against the Kansas department store, alleging fraud relating to the leather couch contract. That's exactly the sort of claim to which the doctrine of res judicata applies, right? Every claim that could have been brought or should have been brought must be brought or it will be barred. So our answer is C. Okay. B is a permissive additional claim, right? Kansas against Nebraska, not mandatory. And D is just another lawsuit, a claim by another department store, right? They could have sued together and were not obligated to do so. So only C is the compulsory counterclaim that has this use it or lose it quality. The next of our topics is the class action. Of course, there's a lot of class action law, some of which is very complicated, but we're going to boil it down just to the sorts of things most susceptible to being tested on the multi-state bar exam. Class actions, governed by Federal Rule of Civil Procedure 23, offer a way to adjudicate many claims arising from a single event or occurrence. For example, a mass tort or a defective consumer product. The plaintiff in a class action is a named class representative, and in order to sue on behalf of a class, there are 5 criteria that must be met. We'll talk a little bit about them to the extent relevant. Numerosity, commonality, typicality, fair and adequate representation, and then concerns about the risk of inconsistent results, the appropriateness of injunctive or declaratory relief, and its superiority to alternative methods, including the predominance of common questions in the claim. All members of the class will be bound by the judgment rendered in a class action, except members of common question class actions who opt out. Procedures about opting in and opting out are quite complicated, but again, fortunately for you, beyond our scope. Rarely, class actions are also diversity classes rather than federal question classes. And in that case, only the citizenship of the named representative is taken into account. That is, there does not have to be complete diversity with respect to every member of the class. However, the amount in controversy must be met by each class member. And so you can imagine there may be some classes like this where the amount in controversy could be met by each one, but these would be, for example, the lethal failure of a medical device or something like that, right? Ordinary consumer products are rarely going to do more than $75,000 worth of damage to each and every person who is injured, even if they do that much damage in the aggregate. That's not how it works. Question 15. A commercial airline was involved in a crash as it was taking off from an airport in Houston, Texas. The crash resulted in the death of 17 passengers and serious injuries to 32 others. The injured passengers and the surviving family members of the deceased passengers wish to sue the airline for wrongful death and personal injuries. The airline is incorporated and has its principal place of business in Texas. The passengers come from 20 different states, including several from Texas. Is it likely that all of the plaintiffs can be certified as a class and file a class action? So we'll use this question to run through these requirements, even though, as you can see, the structure of the answers is no, 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 yes, right? So we will work through it. So, can they be certified as a class and file a class action? So answer A, no, because there are fewer than 50 plaintiffs. As I mentioned just a bit ago, the first of the requirements for a class action is numerosity, but there is no bright line rule about how numerous a class has to be. Certainly, there is no rule that says there have to be more than 50 plaintiffs. That answer is wrong. B, no, because not all of the passengers are of diverse citizenship with the airline. As I just mentioned, only the named plaintiff must be diverse. It's not the case that each and every plaintiff must be diverse from the defendant in the class action, so B is a false statement of the law. C, no, because the survivors of the deceased passengers and the injured passengers will not be alleging the same claim. So that takes us back to commonality, typicality, and some of these other requirements. There must be common claims or defenses, common issues of fact and law. But here, that some people died and some were injured is not a distinction that means they don't have enough in common to make adjudication as a class make sense. Right? If the airline was negligent, if there were parts that were negligently manufactured, negligently maintained, the very same things that contributed to the death of some passengers will be the same things that contributed to the injury of other passengers. And so long as the class representative can show common injuries and typical injuries, right, and adequate representation by that class representative, it doesn't matter that the injury they suffered is not identical. And so that brings us to answer D. Our next topic is discovery. Discovery is, of course, a very large topic in actual federal civil procedure and a huge topic in real-life litigation. But it's a comparatively small subject where the MBE is concerned, much likelier to be tested on a performance test where you might be asked to write interrogatories, review evidence, apply various discovery-related rules, and be familiar with them, rather than in the MBE context. So there are just a few things that it's important to know about. The basic idea that guides discovery under the federal rules is to use pretrial methods both to obtain evidence and narrow the issues. The methods are designed to unearth all material that's relevant and not privileged or reasonably calculated to lead to the discovery of admissible evidence. So one thing to watch out for, just as a purely strategic matter, is to be able to distinguish, although they may overlap, questions that are really just evidence questions, which is also an MBE subject, from questions that are truly civil procedure questions in the area of discovery. So, and nevertheless, we're going to do a question that uses a little of each. That's an older question. Attorney work product is often sought in discovery, so this is an easy way to test both of those issues at once. Materials prepared in anticipation of litigation or for trial are generally not discoverable, but there is a good cause exception, which requires the party seeking the information to show both substantial need and unavailability from other sources. You should be aware that the rules also provide for some sanctions for noncompliance with discovery, including contempt, default, the imposition of costs, and striking of pleadings where there has been failure to cooperate with discovery in relation to the claims made in those pleadings. We have a question that is drawn directly from that area, that is about what is discoverable. Will the police department have to turn over the interview report? Right? So this is sort of a discovery question, sort of an evidence question. An arrestee sues his local police department for civil rights violation under 42 U.S.C. 1983. Immediately following the suit, counsel for the police department conducts interviews with the officers involved to witness the incident. Later, one of the officers dies. Counsel for the arrestee seeks the interview report with the deceased officer in discovery. The deceased officer is the only person other than the plaintiff and defendant who witnessed it. Will the police department have to turn it over? And I hope, just even as a matter of fairness, and even at this late stage of your life as a law student and almost a lawyer, that your intuitions say, yes, they ought to be able to get that report, so we'll be choosing between two justifications. Yes, because the witness is unavailable, deceased. Yes, because the deceased officer is not a defendant. That's clearly coming out of left field as a rule, and so A is the better answer. C and D both raise issues of attorney work product or attorney-client privilege, which are potentially distracting because you notice that it is counsel for the arrestee, right, counsel for the arrestee is seeking it, counsel for the police department who conducts the interviews, right? But this is one of those exceptions, right? It's not attorney-client privilege. The officers involved are not the defendants, it's the police department who is. It may very well be work product, but this is an example of the exception where there's both substantial need and unavailability from other sources because this is the only other witness. Just to recap your familiarity with discovery methods, you want to make sure that you're that you're familiar with these methods and some details about them, not the most excruciating detail. And you want to be aware of which things can be served upon parties and which can be served upon anyone at all. So, interrogatories may only be served upon other parties, and the same goes for requests for admission. But depositions, requests for production of documents and things, and physical and mental exams are potentially served on anyone, meaning any witness, not just a party, if the appropriate limits or tests are respected. So, limits on interrogatories, they're limited to 25, counting subparts, must be responded to in 30 days, must answer under oath. The party can only say they don't know if they've undertaken a reasonable investigation. Limits on depositions, it's a limit of 10. Non-parties must be subpoenaed or they are not compelled to be deposed. Requests for admission must be admitted or denied. They are binding only with respect to the action from which they emerge, and again have a 30-day response. Requests for production of documents and things also have this 30-day response. Non-parties can be served with such requests, but a subpoena is required, whereas for parties it is not. And physical and mental exams are available only through court order upon a showing that the person's physical or mental condition is actually in controversy and good cause can be shown. We have on the next page a very quick recap of the motions to dismiss. We've talked about most of them, and so you want to be familiar with each of them and also their timing requirements. So 12b1, the lack of subject matter jurisdiction, can be raised at any time. That is, the effect of the failure to raise it by motion early on is that there is no such effect. 12b2, lack of personal jurisdiction, is waived if not raised. It's not mentioned here, but it's one you just want to be aware of. 12b3, improper venue, can be raised at a later time if matters of convenience warrant it. If never raised, then waived. 12b4 and 5 are also waived if not raised. These are failure or insufficiency of process of service, of process or service of process. 12b7, the failure to join an indispensable party, can be raised at any time prior to the close of the trial, right? So it actually goes beyond the pretrial period. And 12b6, the failure to state a claim, can be raised also at any time prior to the close of the trial. So you just want to be aware of that in general, and we have a little sort of Mad Lib style fill in the blank on the next page that will take you through some of that. It can be easy to confuse the motion to dismiss with the motion for judgment on the pleadings on the one hand and the motion for summary judgment on the other. So you want to keep all three of those distinct. The primary difference between the motion to dismiss and the motion for judgment on the pleadings is timing. The motion to dismiss is filed before, and the motion for judgment on the pleadings is filed after what? After the answer is filed. Otherwise, they're the same. The standards are the same. The requirements are the same. What both of these motions have in common is that they are based on the pleadings and not on the evidence. And the standard in both cases is whether, taking all the allegations of the complaint as true, the plaintiff has stated a claim upon which relief can be granted. By contrast, the motion for summary judgment requires the court to evaluate the evidence, not merely the pleadings, in the light most favorable to the non-moving party. The motion for summary judgment can be brought by either party, right? And the standard is whether the moving party is entitled to judgment as a matter of law, or instead, triable issues of material fact remain. So it's good to be familiar with those standards and that language. Maybe as likely to come up in an essay question or even possibly a performance test as it would on the MBE. There are a number of jury issues that are potentially multiple choice testable, and you want to be familiar with them as well. What makes them especially amenable to this kind of testing is that there are some relatively clear-cut rules, and so they generate good yes or no situations. So, as to type of case and whether there's a right to a federal jury trial, legal and equitable claims or defenses that are joined in a single suit. Is there a right to a jury trial in federal court? Yes. Federal diversity suits? Yes, because these are typically going to be state garden variety tort and contract claims that would entitle you to a jury at the state level. You get the jury at the federal level. Federal diversity suits on claims that would not be tried to a jury in state court may still entitle you to a jury in federal court. And so, keeping in mind some of those form selection issues, that would actually, form shopping issues, that's one where you might have a reason to prefer one form or the other. However, if the party fails to file and serve a timely jury demand, the right to a jury is waived. A few other important federal jury rules are set out below. I will leave those to be read by you on your own. They are relatively straightforward and ones with which you should be familiar. The last of our topics is the effect of prior adjudication. The effect of prior adjudication is, probably together with the Erie Doctrine, widely regarded as the most complicated thing that falls under the heading of civil procedure in a general way. It is potentially logically rather complicated, but it's very helpful if you understand some of the policies that guide both of the two large-scale doctrines that exist under the general heading of the effect of prior adjudication. The older of these is res judicata, which is now sometimes also referred to in various materials as claim preclusion, and the newer of them, collateral estoppel, which is also sometimes referred to as issue preclusion. So we'll talk about res judicata, claim preclusion, first. Res judicata also belongs on that short list of Latin phrases with which you need to be familiar. And all it means is the matter or thing adjudicated. Res means thing. The idea behind this doctrine is that once a matter has been adjudicated, it is not to be adjudicated again. The goal served by this doctrine is finality and the avoidance of potentially inconsistent outcomes from multiple cases between the same parties based on the same facts, right, arising from the same incident. Res judicata prevents the relitigation not only of the claims actually brought in the first suit, but of all claims that could have been brought in that suit. This is a standard for which I sometimes use the slogan, could have been brought, should have been brought. Right? That is whether they were brought or not. If they could have been brought, they should have been brought. Another slogan here is no claim splitting. You can't use one case to bring some of the claims and see how it goes, and then bring a second case against the same defendant to bring the rest of the claims. In this way, it encourages plaintiffs to bring all their claims and present all their evidence at once. The subdoctrine of merger applies to a plaintiff who attempts to claim split, and the subdoctrine of bar applies to prevent the party who lost in the first suit from relitigating against the prevailing party. That is, not appealing, but trying to relitigate from the beginning. In order for res judicata to apply, there are several requirements that must be met. You want to make sure you understand them. There must be a final judgment on the merits entered by a court of competent jurisdiction between the same parties identically aligned, and what we're dealing with is subsequent litigation on the same cause of action. If that happens, res judicata applies. If all of those are met, res judicata applies. So let's take a look at an example question. A Texas domiciliary is driving a car involved in an automobile accident in Oklahoma, which injures an Oklahoma pedestrian and totals her car. So just for the sake of completeness, even though we already know this is going to be a res judicata case, we'll set it up like our ordinary diversity case. The Oklahoma pedestrian sues the Texas driver for her injuries, for personal injuries in the federal district court in Texas, and prevails, recovering $100,000 for medical expenses and lost wages. That's suit number one. All right, so suit number one. All right, that's suit number one. $100,000 for personal injuries, medical expenses, lost wages. Personal injuries, medical, and wages. You think everything is over, but no. Subsequently, the Oklahoma pedestrian brings a second suit in federal district court in Oklahoma. For property damage to the automobile. This is a classic claim splitting situation. The Texan files a motion to dismiss. Will the case be dismissed under the doctrine of res judicata? I hope you see, yes, easy. This is easy claim splitting and it's not allowed. So, our yes answers are C and D. Yes, because the Oklahoma court lacks jurisdiction over the claim. Well, maybe yes, maybe no, but if we look back to our facts, we see that the automobile accident happened in Oklahoma, so they're going to have jurisdiction over our defendant there. We don't know the amount in controversy, so whatever, this is not what this question is really about. D, yes, because the claim relating to damage to the car was required to be brought together with the personal injury claim, right? And that's what applies here. As I mentioned before, a final judgment on the merits is one of the requirements for res judicata to apply to the subsequent suit. As a result, you need to know which things that might have happened in suit number one will have res judicata effect, as which things falling short of what we saw in our last question, which is a judgment on the merits and an award of damages to our plaintiff. What things short of that outcome still have res judicata effect and will bar a subsequent suit by the same plaintiff. As you want to keep in mind generally, in addition to voluntary dismissals sought by plaintiffs who choose not to pursue an action for any of a variety of reasons, including settlement. Cases can also be involuntarily dismissed for a variety of reasons. We ran through all those 12B reasons. The basis of the dismissal affects whether a dismissal has res judicata effect. So keep in mind, this is a dismissal. We never even got to the evidence often, and in any event, there was never a trial. So what things falling short of a trial on the merits resulting in a judgment will have res judicata effect. Default judgment is another of those ways in which a case might end early. So we need to know which of these have res judicata effect and which do not. A voluntary dismissal ordinarily does not, unless the plaintiff voluntarily dismissed a prior state or federal action, including the same claim. So you get one voluntary dismissal without res judicata effect, but the second one will have res judicata effect. An involuntary dismissal for lack of jurisdiction, no. Because if it's for lack of subject matter jurisdiction, a state court is an appropriate venue, so we wouldn't want it to be barred. And if the dismissal is for lack of personal jurisdiction, there is another state, typically, where personal jurisdiction would be proper, and so we don't want the case to be barred. However, an involuntary dismissal for failure to state a claim, a 12B6 dismissal, does have res judicata effect. An involuntary dismissal for improper venue, no, because there is a proper venue, and that's where we want the case to go. For failure to join an indispensable party, no. Again, this is a situation in which the failure to join an indispensable party results in that party's joinder and dismissal for lack of jurisdiction, and brings us back around to that. There is a proper place for this case, it's just typically not the federal court in which it was brought, and so we don't want there to be res judicata effect there. A default judgment, however, entered against the defendant who fails to plead or otherwise defend has res judicata effect. And as far as why that might be significant, that is, why would a plaintiff who has won a default judgment sue again? It might be because they did not sue for the maximum amount of damages they might have wished to recover, and default judgments are limited to the damages sought in the original complaint. And so a plaintiff will be held to those damages and can't go back for a second bite against that defaulting defendant. Our last issue, again falling under the heading of the effect of prior adjudication, is collateral estoppel, also known as issue preclusion. For many students, res judicata is a little easier to understand than collateral estoppel and easier to recognize because it only applies to the same parties litigating the same case. And so once you change the parties, once you change the case, it's obvious that res judicata won't apply. The only wrinkle with res judicata is that it applies even to claims that were never adjudicated in the first case, the claim splitting issue. Collateral estoppel, by contrast, is issue specific and can, under the right circumstances, apply in a later case, one of whose parties was not involved in the prior suit at all. That is, collateral estoppel does not have the same party's requirement. The basic definition or rule of collateral estoppel is this: a final judgment, so it has that same final judgment requirement as res judicata, is conclusive as to all issues actually litigated and necessarily decided. So notice, it does not have that could have been brought, should have been brought quality. It only applies to the issues actually litigated and necessarily decided in the prior action. It is conclusive as to any party who had a full and fair opportunity to litigate the issue in the prior proceeding. Collateral estoppel, as a result, can only be used against a party in the prior suit or one in privity with such a party. But it may potentially be used by a non-party, so long as the party against whom it is used had a full and fair opportunity to litigate the issue, and it would not be unfair under the circumstances. Keep in mind that collateral estoppel does not bar litigation over issues not actually raised, even if they could have been raised in the prior suit. Again, does not have, could have been brought, should have been brought. So let's work through a couple of examples, and then we'll be done. Number 18. A consumer purchases a bottle of shampoo. When she uses it, it turns her hair green, and subsequently all her hair falls out. She sues the shampoo company, tongue twister, for negligence. She prevails in her suit, and the jury specifically finds that the shampoo was negligently compounded and manufactured. The verdict is widely publicized, and approximately 100 other users of the same brand of shampoo file their own lawsuits. May these plaintiffs use the result of the prior suit to prove negligence on the part of the shampoo maker. So it may seem to you that this is potentially unfair, and maybe it is. That is, maybe the shampoo company will not have defended as vigorously against a single plaintiff as they might have had they known there were 100 plaintiffs or more waiting in the wings. Nevertheless, if we step through our requirements, we will see, right, that collateral estoppel applies here. This is an example of a non-party's use of collateral estoppel. The issue was actually litigated, right? The negligence in manufacture and compounding. It was necessarily decided. That is, had the jury found that it was not negligently compounded and manufactured, they would not have found for the plaintiff. And the defendant had a full and fair opportunity to litigate. And so, our answer is B. Again, you might be a little bit seduced by D, but the requirements are clearly met, and B is our better answer. And our last question in this unit, a buyer backs out of a real estate deal, having paid a deposit of $10,000 to an escrow company. In a suit between the buyer and seller, the court determines that the $10,000 deposit belongs to the seller as liquidated damages for the buyer's breach. So, a quick cautionary note about a question like this. If you have not jumped ahead to the call of the question, you may think you are answering a property question. So just to kind of get your head into the right place, you do want habitually to look at the call of the question, although this question is so short that even if you thought that, you get straightened out pretty quickly. So if we jump ahead to the question, will the escrow company be able to use the result in the prior lawsuit to bar the buyer's claim, right? Bar the claim, right? That's an effective prior adjudication kind of question. Now we'll head back to the facts. So buyer backs out. Suit between buyer and seller. The court determines that the $10,000 deposit belongs to the seller. So again, it really helps, even as simple as it might seem, right, to make a simple chart. So we have suit number one. That's buyer versus seller, and seller wins the $10,000, gets to keep the $10,000. The buyer then sues the escrow company seeking return of the funds. So that's kind of weird, right? This is losing buyer sues the escrow company to try to get the money that has already been awarded to the seller. The escrow company seeks to use the result in the prior suit to bar the claim. Okay? So I hope it seems to you clear that they should be able to do so, right? That the buyer shouldn't be able, in effect, to go around behind the back of the seller and get money back from the escrow company, get a potentially inconsistent result here, right, that will then leave the seller without a remedy, right? That's not okay. Right? So, again, we can look at those same requirements, right? We have a final judgment. That's not the issue. Was it actually litigated and necessarily decided whose money this is? Yes, it's the seller's, not the buyer's, right? And did the party have a full and fair opportunity to litigate? They did, right? That is, the buyer had a full and fair opportunity to litigate. Did. They were the plaintiff, right? Presumably they made every argument they could possibly make, and they lost. So, can the escrow company, not a party to the prior suit, use the result? Yes, they can. Let's see which answer is better as between A and B. A, because the buyer had a full and fair opportunity to litigate the issue in the prior suit, which is true. And B, because the escrow company and the seller are in privity with one another. They might be and they might not be. The escrow company might be neutral. They might be in privity with the buyer. This depends on adding facts to the question. You want to resist that temptation. And so, our better answer is A. Just for the sake of completeness, what's wrong with C and D? No, because the escrow company was not a party in the prior suit. That doesn't matter, right, if we're talking about collateral estoppel and not res judicata. And D, no, because the issue of the escrow company's right to the funds was not necessary to the prior judgment. And that might be tempting, right? Because it doesn't seem like the escrow company's rights came into play at all, but it's not the escrow company's rights that are an issue here either. It's the buyer's rights. And the issue of the buyer's rights to the funds has been fully litigated and was necessary to the decision of the prior case. That's all. Best of luck to you all on the bar exam.